We're not the judges.
Right. Good evening. On behalf of the Board of Student Advisors, we welcome you to this year's final round competition of the Ames Moot competition. Excuse me. We're especially pleased with this year's panel, and as you know, we have worked with these contestants and seen them progress through two former rounds, the semifinal round and the qualifying round, successfully, and here they are today. My name is Kathy Jetstein. This is Joe Cook and Adam Schiff, and we are members of the Board of Student Advisors in the final committee round. Tonight's record has been written and developed by Professor Larry Tribe and Will Hunter, his assistant.
Judging tonight's competition will be the Honorable William J. Brennan, Jr. of the United States Supreme Court, the Honorable A. Leon Higginbotham, Jr. of the Third Circuit Court of Appeals, and the Honorable Stephen G. Breyer of the First Circuit Court of Appeals.
In case you weren't able to get a copy of the briefs, let me let you know who the teams are. Petitioner and cross-respondent are represented by Jean Marie Brescia, Josephine Fehrenbach, Jay Rothman, Michael Tankersley, Carl Thurmond, and Dennis Wagner. And the oralists for that team are Josephine Fehrenbach and Michael Tankersley. The respondent and cross-petitioner is represented by Charles Blanchard, Chai Feldblum, Elizabeth Harper, Richard Keck, Bruce McCoy, and Robert Thomas. And the oralists for that team are Chai Feldblum and Robert Thomas. I'd like to mention that after the arguments, you're all invited to a reception over at the John Chipman Gray room, and that's over in Pound, second floor. And welcome.
Good luck. Good luck. You'll be able to photograph the judges as soon as they come out. We'll allow like a minute or so, and after that, there'll be no participation, please.
All rise. The Honorable, the Chief Justice Brennan, and the Associate Justices Higginbotham and Breyer of the United States Supreme Court. Oyez, oyez, oyez. All those having business before the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Back.
Miss.
Well, I got the right. No, it's Mr. Tankersley. I beg your pardon.
May it please the court. My name is Michael Tankersley, and along with my co-counsel, Josie Frohnbach, I'm representing the petitioner in this proceeding, the Ames Superintendent of Medical Licensing, Louise Mitchell. I will be arguing that the appellate court improperly refused to abstain, that Dr. Stimson does not have standing to assert the state's 10th Amendment rights against state officials in this action, and that Ames' participation in the voluntary funding program does not impair its sovereignty in violation of the 10th Amendment. Ms. Fornbach will be arguing that Dr. Stimson does not have standing to assert the parents' alleged right of parental autonomy, and that no such right exists to prohibit government from protecting handicapped infants from a course of treatment, in this case, which would deny them the medically indicated procedures they need to survive. This case presents the question of whether a state, acting in cooperation with the federal policy, can regulate its medical profession to protect handicapped infants from a course of treatment which is deliberately calculated to result in their death. It also raises the threshold question of whether a federal court should intervene and disrupt an ongoing state proceeding which is authorized to decide this issue. The facts briefly stated are these. On June 2nd of last year, a severely handicapped infant died, less than 5 months after its birth, because the respondent, Dr. Henry Stimson, recommended, and the child's parents agreed, to withhold the medically indicated procedures necessary to treat its birth defects. The Child Abuse Prevention and Treatment Act amendments of 1983 define withholding such treatment as a form of child abuse and require that states like Ames that receive federal child abuse grants adopt procedures to ensure that handicapped infants receive medically indicated treatment. Pursuant to this mandate, the Ames Superintendent of Medical Licensing initiated state procedures against Dr. Stimson to determine whether his license to practice medicine in the state should be revoked because his conduct was unprofessional. As required by the Ames Unprofessional Conduct Statute, a hearing was scheduled at which Dr. Stimson would be permitted to present all legal and factual questions to an impartial 3-member panel. But this proceeding has been halted for the last 16 months because the Ames Circuit Court of Appeals determined that the federal court should intervene and halt this proceeding before it had even been convened. Every one of the reasons offered by the appellate court and the respondents to justify this disruption of the state licensing action violates this court's policy of deference in favor of state proceedings.
Well, now, what chance has the doctor in the state proceedings to have his constitutional claims determined? What chance has he? What chance has he of having his constitutional claims decided in these administrative state proceedings?
Well, Your Honor, this particular proceeding authorizes him to raise any legal issue.
I know. I'm asking you, what can the agency do about deciding constitutional claims?
Well, Your Honor, this agency can determine that this particular licensing action...
They're 3 laymen, aren't they?
No, Your Honor, that's not correct. What the respondents and the appellate court are trying to do in this proceeding is assume that the state officials will appoint 3 laymen to this panel and thwart Dr. Stimson.
Well, do you know they're going to appoint 3 judges or 3 lawyers?
No, Your Honor, we don't. But the court's doctrine of abstention precludes any assumption by a federal court that the state will act in a manner...
Whose doctrine?
Excuse me?
Whose doctrine?
The abstention doctrine of this court.
Where?
The decisions following that in Younger v. Harris...
What decisions?
Excuse me?
What decisions?
The policy articulated in Younger v. Harris, Traynor v. Hernandez, Moore v. Sims, Judica v. Vail, all indicate a federal...
You haven't any case precisely in point, do you?
No, Your Honor, we don't. But our argument in this proceeding is that that policy and the principles of that policy of abstention preclude having the federal court find that this proceeding is inadequate by assuming that the state officials will thwart Dr. Stimson's statutory rights. All those cases state that unless the...
Would you take this same position if you knew that the members of the panel were going to be 3 doctors?
Your Honor, if it was a lay panel which was being appointed,
Yes.
The additional provision in this proceeding for de novo review provides an adequate opportunity for Dr. Stimson to have his claims heard.
By 4 or 5 years later, you mean?
No, Your Honor, that's not correct. This proceeding must take place within 2 months after the initial determination is brought, and there's a direct...
Not the de novo review.
No, Your Honor.
No, that could take years, mightn't it?
Yes, it could, Your
And
Honor.
meanwhile, he stands without a license and unable to get any constitutional determination, right?
No, Your Honor. The constitutional determination he has is that offered by the state's appellate process. And that is what...
Again, have you any precedent in point in this court?
No, Your Honor. There's not a precedent on point on this. We are arguing from the principles that the court has articulated under the abstention doctrine. And it is our position that those principles require that the state also abstain in this case. The Court's previous decisions have indicated explicitly that the mere burden of having to take an appeal from an initial determination is not the type of irreparable injury which will justify the federal court intervening.
Counsel, it's only been since Younger that this court has considered the abstention doctrine in non-criminal cases. I think there was just an extraordinary dissent in the Younger case. Why shouldn't we, at this point, reconsider making the dissent in that case now the law?
Well, Your Honor, it's been since Hoffman that this court has applied the abstention doctrine to civil proceedings. And our position is that...
Well, Younger was a civil proceeding. It was a nuisance action, as I recall.
No, Your Honor.
Which was going in the state court.
That was Hoffman, Your Honor. But our position is that where the state is acting in this particular proceeding, which is a quasi-criminal proceeding, in its sovereign capacity to enforce this standard against an official, the deference required is equally applicable. And the same disrespect for the state proceedings would occur if the federal court were to authorize intervention. Moreover, there's the additional problem that with this particular proceeding, there's a limitation on the state's authority to independently structure its procedures. For the federal court to intervene in this particular proceeding would thwart the state's ability to provide this special kind of hybrid proceeding to adjudicate these claims.
Well, in Hoffman, Justice Rehnquist, writing for the court, said that there were some special circumstances where you could still have the federal courts act without the delay, without abstention. What more could happen to a physician than to be precluded from the right to practice his profession?
Well, Your Honor...
What would have to happen before you would apply the exception which the court spoke of in that case?
The exceptions which the court has explicitly identified is where the action is brought in bad faith, or the statute itself.
Well, they said more than that.
Well, Your Honor, I think in the cases which have developed what those exceptions are, it has been stated that they are a bad faith prosecution and a statute which is totally unconstitutional in its face. And the court has explicitly said that merely the presence of an unusual circumstance is not enough to justify
No, but
federal
Mr.
intervention.
Tankersley, does there not have to be some kind of state interest at stake?
Well, Your Honor...
Does it, yes or no?
Yes, Your Honor, that's correct.
Now, on the merits in this case, the real confrontation is between a federal statute and the federal Constitution, isn't it?
Yes, Your Honor.
Now, what possible state interest does Ames have in the resolution of that kind of confrontation? Isn't that purely federal?
Well, Your Honor, Ames has adopted this federal standard as its own and is seeking to enforce it in this particular quasi-criminal proceeding.
Well, perhaps Ames has. But can Ames, unless the federal statute's constitutional?
No, Your Honor, but that's not the issue in abstention. Abstention's focus is on the integrity of the state proceedings themselves.
That's actually, see, I'm sort of new on this court. And I know obviously we're reconsidering these cases, and there are a lot of good dissents in some of them. But I think, as Brethren said, that look, there seems to be this doctor who's about to lose his license, and in the state, if he has to go through the state proceeding, I think it says here that one of those people in the state proceeding shall be a licensed physician. So I suspect that that particular person's not a lawyer, though you never know for sure.
That's correct.
But all right. And then they're going to have this de novo proceeding. So on the one hand, I think this doctor it's going to take a long time, and he might lose his license in the meantime before they even decide the issue. And some people might get mixed up and not even understand there was an ethical question. They may think he's a bad doctor. They may think he's incompetent. He'll lose all his practice. And that seems to be on the one hand, and on the other hand, it seems to me that all that's at stake is you'd have a federal court deciding a federal question now, or some kind of a state court deciding the federal question sometime in the future and hurting the doctor. All right, now what is it, given that set of circumstances, that would lead this court to say, oh, you No, we won't touch it. Let the state do it in the future, hurt the doctor, and have the doctor decide the legal issue, and have then the state court do it, and sometime it'll get up to the Supreme Court again. Why should anybody do that?
Well, Your Honor, I think the point is, and it's a point which carries through both the majority opinions and the very eloquent dissents in the abstention cases.
That's right, very eloquent.
The point agreed to by all those members of the court is that the federal courts have a responsibility to recognize the fact that state tribunals are also authorized to determine federal issues, and deference and respect for the authority of those tribunals to decide those questions requires that the federal courts not step in, halt a state proceeding, have the state's enforcement action grind to a halt on the premise that they're going to disrespect the ability of the states to handle that through their own procedures. And that's the concern of the abstention doctrine reflected in all those cases. At this point, I would like to move on to Dr. Stimson's argument that he has standing to assert the 10th Amendment rights of the state against state officials in this action. The 10th Amendment right recognized by this court in National League of Cities is not an individual right, but an intergovernmental immunity which protects the ability of states to exercise their sovereign authority. The point and the clear expression of National League of Cities and other cases in which this court is...
But, Mr. Tankersley, before you get to National League of Cities, there isn't any question, is there, that this doctor has suffered injury in fact, hasn't he?
No, Your Honor, there's
Why
no
not?
question.
He's lost his license.
No,
Can't
Your Honor,
practice.
you're quite correct. He has standing,
Well,
and the injury in fact is that.
Isn't that a pretty severe injury in fact?
We're not at all denying he has standing to bring this action. We're denying that he has standing to assert the 10th Amendment rights of the state. As this court has consistently said...
You mean on behalf of third parties?
On behalf of the state.
No, but he can't assert, I gather, the argument, as I understand your brief, is that he can't assert the rights of the state, 10th Amendment rights of the state, in behalf of third parties. Isn't that your argument?
Well, the third party in this instance is the state itself, Your Honor. And
I thought it was the parents, no?
well, that's a later argument. It is also, in both issues, third-party standing is involved, and Dr. Stimson is trying to invoke that extraordinary ability, which the court has only granted in extremely limited situations, to have the court adjudicate the rights of third parties on his behalf. In this instance, he's trying to assert the rights of the state of Ames under National League of Cities, a case which distinctly creates a special right on behalf of states and the exercise of their sovereign authority. In that case and others, explicating the meaning of state within the Constitution, indicate when citizens act together in their political capacity to exercise the sovereign power of their state, they have special rights and powers under the 10th Amendment, which they do not have in their capacity as individuals. And Dr. Stimson does not have standing to assert those rights when the state is actually in an adversarial relationship to him and is not at all claiming that its rights have been violated in this proceeding.
Do you suppose the National League of Cities is at risk?
Well, Your Honor, I think the decision itself will stand, but its limits still are yet to be defined.
After Wyoming, you think it still stands?
Well, Your Honor, I think that imposes a very severe limit on the case itself. And with that, I would move to Dr. Stimson's argument on the merits of the case, and that the 10th Amendment prohibits the federal government from seeking to influence the policy of the state with respect to child abuse in this particular proceeding. The National League of Cities test has never been extended to voluntary funding conditions for the very good reason that these particular programs do not impose a direct imposition on the ability of states to run their programs, but are voluntary programs. Moreover, they do not result in the forced relinquishment of states' abilities to provide services, but indeed expand the abilities of states to provide services to their citizens by providing federal funds.
I've never understood. I mean, so the Constitution says the federal government can't tell a state to do thus and so. So what the federal government says, we're not telling you to do thus and so. We're just telling you we're not going to give you a penny unless you do thus and so. And then you say, oh, that's voluntary, because after all, you could take no money for to give back the $50–60 billion
For your citizens. Now, I mean, why does that make a difference? In other words, people can't really refuse this money, can they?
No, Your Honor, I think they can, and they have. states have consistently done so. But the concern of National League of Cities is not to limit the ability of the federal government to influence the states, because there's always going to be an interrelationship between federal policy and that of the states. The concern of National League of Cities is with the states losing their ability to provide certain services. And it's clear that when the federal government offers them money to supplement an existing program to expand their ability to provide services, that concern is not at issue. Moreover, the particular conditions here clearly reflect a valid national policy in terms of trying to provide for the protection of these children and this form of child abuse. And the court has consistently upheld the authority of Congress under the spending power and the commerce power to influence the policies adopted by states.
May I interrupt you just a minute, Mr. Tankersley? You say that this particular form of child abuse. Now, I gather this centers on what is the meaning of medically indicated, does it?
Well, Your Honor, that is a question of interpretation under the statute,
Well,
but this particular argument does not turn on that.
Are you so sure that the interpretation you suggest of those words is the sound one?
Well, Your Honor, it seems from the briefs that both sides indicate that the HHS regulations previously promulgated are relevant to the interpretation of those terms.
Yes.
And our interpretation is based on those regulations. And that is the basis for our contention.
Well, is medically indicated synonymous with surgery?
No, Your Honor. It's synonymous with surgery which will result in a clear benefit to the patients, in this case, the handicapped child's condition.
Yes.
And that is the interpretation given in the HHS regulations, which both sides have cited for clarifying the meaning of those terms.
Isn't there an issue before us whether medically indicated does cover what would be required in this instance?
No, Your Honor, there doesn't seem to be any dispute between the parties that the procedures which were not provided here were medically indicated and would have resulted in benefit to the child's condition. Finally, these particular provisions represent an attempt by Congress to effectuate the objectives of the 14th Amendment. Congress has the ability to directly impose this type of conditions on the states under its power under Article 5 and without violating the 10th Amendment.
Well, not if the legislation under Section 5 is inconsistent with the requirements of Section 1.
That's correct, Your Honor, but that's a question.
Isn't there an issue here whether it is?
Well, that's a question which goes to the substantive constitutionality of the substance of the federal regulation, which Ms. Fornbach will be addressing in saying that this does not violate parental autonomy. But with respect to a 10th Amendment violation, that concern is not present here. And the fact that Congress could impose this condition mandatorily on the states indicates that it cannot be a violation of the 10th Amendment when it acts through the less coercive means of offering it as a condition to federal funds in order to encourage states to adopt this particular policy and these particular procedures in trying to eliminate this form of child abuse. Thank you very much.
Thank you. Ms. Fornbach?
May it please the Court. My name is Josie Fornbach, and as co-counsel for the petitioner, it is my task tonight to demonstrate why Dr. Stimson should not be granted standing to assert the rights of parental autonomy in this case. I will then go on to examine why, in fact, even if this statute is applied to parents, why it is a constitutionally justifiable measure necessary to vindicate the rights of handicapped newborns, while not, in fact, violating any existing right of parental autonomy. This Court has developed a prudential policy to avoid the premature adjudication of valuable rights. That policy denies a litigant standing when he seeks to assert the rights of absent parties, when in fact the litigant's rights and those third-party rights are not inextricably bound.
Yes, but aren't his rights, in this case at least, rather closely intertwined with the rights of the parents?
While the rights are related, they are not inextricably bound together or mutually interdependent. That is...
Well, I said intertwined.
They may be intertwined, but not intertwined to the extent that we would necessarily allow him to assert the parental rights involved, because it is not necessary to protect Dr. Stimson's action in this case, that of prescribing the withholding of medical
Well, I know, but
treatment.
if either he or the parents have standing, either one, then we don't have to go further with the issue of standing, do we?
No, that's not correct, Your Honor. While he may have standing to assert his own claims, what Dr. Stimson is seeking to address here is a challenge to the Constitution.
No, I said if he has standing to assert the rights of the parents, or the parents themselves have standing to assert their rights, isn't that the end of the issue of standing?
Well, Your Honor, the parents are not here to represent their own rights. Dr. Stimson is seeking to borrow their rights, in a sense, for this proceeding and to present their claims for you. However, when a litigant seeks to, in a sense, borrow third-party rights, this court must be careful to make sure the interests of those two parties, the litigant and the third parties, are consistent in order to prevent perhaps error on the merits.
On the point of intertwinement, how can a doctor give advice without having a patient to give the advice?
Oh,
And he is giving advice to the parents as the representative of the patient. So it's impossible for him to not have to interact with the parents, and if he does, it seems to me that the rights merge.
well, I must disagree as to that application of your analysis of this case, Your Honor, in that protecting Dr. Stimson's particular form of advice here is not necessary in order to allow the parents to make their decision. That is, Dr. Stimson is not offering here advice on the child's medical condition. That would be the advice he is competent to offer. Instead, he is seeking to interject a moral evaluation on his part, an appraisal of the value of the child's life. It's interesting to note as well that the parents here would assert a right.
I don't understand. I mean, I thought the parents are saying that in this rather difficult area, they have a right to decide whether to go ahead with the treatment or let the child die. That's the right they're asserting, isn't it?
Yes, that's correct.
Well, how can they exercise this right if a doctor is forbidden to explain in detail to them what it means to live or to die or to perform the operation or not, and then to either offer to perform it or offer not to perform it?
Well, Your Honor, he is not, in fact, prohibited from making all medical representations. And, in fact,
Why is his
described in
license
contempt.
being removed?
Because what the doctor went on to do was to advise the parents to withhold treatment in this case. The parents had not made a decision. As the record indicates on page 6, they rejected the surgical treatment alternative on the basis of the doctor's advice.
What he advised them was not a criminal act. It's my understanding in this state. It's never been declared. The advice he gave to before be a crime. It's never been declared to be unprofessional.
But the state is now acting under the instruction of this new federal standard, which recognizes in this very difficult and sensitive area there is a grave potential for the abuse of these children, in that the value of their lives may be extremely underestimated by both parents and physicians involved in these difficult treatment decisions. Therefore, the previous application of criminal liability to physicians or parents in this situation is not instructive as to the particular application of the new federal standard in this case.
Would it make any difference to you if instead of dealing with a baby a few weeks old, if you were dealing with someone who was 89 years old or 90 or 105 years old? And if he said, well, look, they've had their century and two, and rather than to go through this operative procedure to prolong their life, I think you should give them antibiotics and let them leave after a century on this earth in peace.
No,
Would make no difference?
we would afford the elderly patient no less protection than the newborn patient. Because one exists at one of the edges of life, there's no reason for denying a person the protection of the Constitution. I would like now to address...
Well, before you do, may I ask this? Each of my colleagues has suggested to you, I think, that, or ask you the question, what possible service can the doctor render unless he has a patient to whom to render it? And it would not, in these circumstances, either be baby itself or parents?
The patient involved here is necessarily both
Yes.
the parents and the
Yes, well now,
baby.
haven't we settled in Craig and Warren that there is standing to assert concomitant rights of third parties that would be diluted or adversely affected should the doctor's own constitutional challenge fail and the statute remain in force?
Well, should Dr. Stimson's challenge to the statute fail,
No, no. If that should fail, may he not assert the parents' right under our decision in Craig and Boren?
No, we would,
Why
Craig v.
not?
Boren would not advise that, because in Craig v. Boren, what was involved was that the vendor could not sell alcoholic beverages to underage males. Those underage males could not exercise their right to be free from gender-based discrimination. But in this case, if Dr. Stimson is not protected when he makes ideological prescriptions, parents may still retain their right under a narrow interpretation of the statute to in fact make the ultimate decision. Therefore, in fact, parents might want to assert a right to be free from the doctor's ideological representations. After all, they are asserting a right of parental autonomy based on their unique competence as parents. And if their decision is...
That may be that they have standing without question, but why can't he, if their rights are going to be diluted if he doesn't assert them?
Because, in fact, allowing Dr. Stimson to assert these claims might, in fact, endanger the rights of the third parties, in that this court will use him as its prison for refracting the
Maybe someone could argue, looking at Craig, that the substance of your argument is that someone who sells beer has more rights than someone who's a surgeon.
No, Your Honor. Clearly that is not. That's an exaggeration of our position.
Oh, maybe he should.
Well, that might be one chosen characterization. What we feel our position is that, in fact, whereas in Craig v. Boren, as I have previously tried to explain, if the litigant's conduct was not protected, the third parties could never exercise their right. But in this case, the parents could conceivably exercise their right, and in fact might choose to exercise that right free from the doctor's role in the decision. After all, these parents, as everyone has admitted, are subject to extreme emotional duress in the process of making the decision. And the doctor's interjections may, in fact, endanger their capacity to make a decision by someone...
Suppose that, look, I mean, suppose this frightful thing happened to one of us. Isn't the first thing you'd like to know, what does the doctor think about this? What are the chances? What should I do? Now, let's suppose that this statute is unconstitutional for the sake of argument. Because a parent is supposed to have the right to make this choice. Well, then your position suggests nobody's ever going to be able to challenge this. I mean, the parents have been kicked out of the case. The doctor, you're saying, can't challenge it. He is going to lose his license because a statute that is unconstitutional is being enforced against him. What sense would it make to say that he doesn't have standing? Are you supposed to apply unconstitutional statutes to take people's doctor's licenses away, and would that not prevent him from advising the parents, and they would be left not knowing what to do? That's like a 15-part question.
I'll attempt to make some headway into it. Your Honor, in this situation, even if Dr. Stimson's conduct would be regulated, the parents might still retain some right to make the decision. And to bar, what is really important for the court to look at this point is whether or not Dr. Stimson can be an adequate representative of parental interest. There is a grave danger here that by using Dr. Stimson as the prism for refracting the parent's constitutional autonomy right, you will incorrectly focus on what the nature and scope of that right is. The right is clearly important and is one which perhaps because of its delicate and difficult nature can only be represented by the right holders themselves. It is not inconceivable that the parents could bring a challenge to this statute, although these particular parents who were uninjured by the operation of the statute, Petitioner Mitchell applied the statute only to them, and so the court would be forced in this situation to engage in an evaluation of hypothetical applications and not the concrete circumstance presented by this controversy. I would now like to address the merits challenge to this statute and argue that, in fact, the focus of this court must be on the constitutional rights of the severely handicapped newborns in this case. It is indisputed that those infants do merit constitutional protection. And, however, respondent has chosen to incorrectly characterize this as a means of completely excluding parents from the parental decision-making process. What this statute actually seeks to do is simply to establish a standard to be used by all involved in making the decision, and a standard based on the only knowable criteria available in this agonizing situation. No one can accurately appraise what the value of the child's life is to the child, but an objective assessment can be made of what the child's medical conditions indicate and what surgery or other procedures are available to correct those defects.
Suppose a child is so badly malformed that it's going to die. Unless you perform an operation which would keep it alive for 5 minutes more at the cost of $50 billion. All right, nobody would say that that's something that has to be performed, correct?
And that would not be medically indicated
All
treatment,
right,
Your Honor.
then if that's so, then how, and it isn't, would we not interpret the word medically indicated here to mean, in order to avoid a difficult constitutional question, that this statute does not apply to the case before us either?
No, Your Honor.
Otherwise, we have to face a very difficult constitutional question. So should we not interpret the statute that way to avoid it?
Although we would advise the court to avoid the constitutional question by not granting Dr. Stimson to assert the parental rights, we would not urge...
You mean throw him out of court and then we don't have to reach the merits?
Well, we feel our claim is strong on the merits. So, Your Honor, we're willing to allow consideration of the parental
Well,
autonomy
may I ask
claim.
just one question before you get into that? I gather there's no disagreement that there's involved here the spending power, and in that sense, a grant to the state. But before you can say that Congress has really invoked its spending power, don't any conditions it imposes on the grant have to be must satisfy the rule of clear statement?
Well, Your
And
Honor,
does this statute, my heavens, I'm glad it's not really been passed by the Congress. Does that satisfy the requirement of clear statement?
yes, we feel that the statute does...
Where do we find it? In K. Can you tell me the exact language at the top of A3 of the...
Yes, I have it before me,
Yes.
Your Honor. Thank you.
Yes.
Well, we feel that the specificity of the statute, the fact that it indicates to states that they must, and I will read the language, supply procedures consistent with the Act to be followed by child protective service agencies, health care facilities, health and allied medical professionals, health care licensing authorities, etc., that this explicit listing of how the state can invoke its enforcement mechanisms to uphold the statute, as well as the medically indicated criteria, do in fact give instruction to the state that is easily understandable and ascertainable. The Haldeman Clear Statement Rule involves a situation in which the state would be forced to incur enormous financial burdens, and without any instruction, arguably, from the Congress as to how it could fulfill its congressionally mandated conditions.
This all come down to that the words medically indicated
That's right.
itself import the necessary clear statement.
Well,
Is that right?
yes, medically indicated standard.
Have you any other instance where we've applied the requirement of clear statement on language that ambiguous?
Well, Your Honor, we do not feel that the medically indicated language is in fact ambiguous. To move for a moment back to Justice Breyer's question in order to perhaps clarify the court how medically indicated can easily be interpreted. In this situation, a child suffering from spina bifida, hydrocephaly, microcephaly, those specific defects can be remedied by certain medical procedures. The procedures were not undertaken because those conditions would not be improved by the performance of that surgery. Procedures were not undertaken because the parents and the doctors decided that the value of life to the child would be negligible and the child would not want to proceed. Medically indicated is an ascertainable and understandable standard based on assessment of the child's objective medical conditions. We feel that this statute is indeed constitutionally justifiable, and we would strongly disagree, as the respondent contends, that it is in some way, the Congress is in some way barred from acting simply because there is a moral and social controversy surrounding this circumstance. Rather, we would believe that the imposition of a moral or popular consensus prerequisite would functionally incapacitate Congress from acting to protect vulnerable minorities, a historic and noble function, in fact, of our nation's legislature. Therefore, for the foregoing reasons, we would urge this court to uphold the constitutionality of subsection K if it decides to allow Dr. Stimson standing to assert parental rights. Thank you.
Mr. Thomas?
it please the court. My name is Robert Thomas, and my co-counsel, Hy Feldblum, and I represent Dr. Henry Stimson, the respondent. At issue in this case is who shall decide the proper course of treatment for severely handicapped newborns, parents or the federal government. I will be addressing the issues of abstention and federalism, and my co-counsel will address the constitutional issues of privacy. The abstention doctrine of Younger v. Harris is wholly inappropriate here. On the facts of this case, the traditional requirement of deference to ongoing state proceedings simply does not apply. Never before have federal courts extended the abstention doctrine as far as this case would in fact take it. And this court should not deny Dr. Stimson his right to seek review in federal court when none of the principles of Younger v. Harris require it. Only 2 years ago, in the Middlesex opinion, this court elaborated on the Younger doctrine. And in that opinion, the court held that 3 factors must be considered in determining whether or not a federal court should abstain out of deference to administrative proceedings. And the 3 factors were, first, that there must be an adequate opportunity to raise the constitutional claim. Second, important state interests must be implicated by the case. And third, the procedures must constitute ongoing judicial proceedings. The Division of Medical Quality, the panel in this case, fails under all 3 of these standards in the Middlesex opinion.
Well, may I ask you about the third first? Is this the procedure of Ames, which can result in the loss of the doctor's license, and did indeed in this instance, is that really a civil kind of procedure? Isn't it at least quasi-criminal?
Your Honor, it's not clear how the state of Ames characterizes this proceeding. However, I would like to point out that it has none of the judicial safeguards that characteristically are present.
No, but some of the court's decisions that have dealt with state proceedings have indicated that abstention may be more appropriate where the state proceeding is quasi-criminal in nature. Have they not?
That's correct, Your Honor, and those courts have...
And why doesn't that principle apply here?
Well, Your Honor, those courts that have held that in those instances have looked to the state law, and they have looked to see whether, in fact, the state in question regards that procedure as quasi-criminal. Yeah. We simply have no assurance in this case that the state of Ames, in fact, views this procedure as quasi-criminal. Moreover, Your Honor, the rare instances when federal courts have abstained out of deference to civil administrative or state administrative proceedings have been those where literally the administrative body was an arm of the court or where it had full judicial characteristics.
Well, how can you say that in view of Williams versus Red Bank Board, where you did not have a judicial body, where New Jersey did not require the hearing officers to be lawyers, and the Third Circuit held that abstention would apply?
There are several distinctions, Your Honor, but on this particular point of the judicial characteristics, in that case, there was an administrative law judge. There was the ability...
Yeah, but it's an administrative law judge who doesn't have to be a lawyer.
That's correct.
What Judge Garth said in his opinion.
That's correct, Your Honor, but still one has more confidence knowing that...
By the label, you mean you'd be perfectly willing to take someone off the street, and as long as you say, look, you are an administrative law judge, but you haven't studied law, you don't know anything about it, but you've got a good title. And that would be enough.
No, Your Honor, that's not the point. The issue here is whether or not this court, in looking at the state of Ames Division of Medical Quality, has enough confidence in its ability to provide Dr. Stimson an adequate opportunity to vindicate his constitutional right to say, let the state proceeding go ahead. And I assert to you, Your Honor, that from a reading of the statute and from an examination of this record, we simply can't have that kind of confidence about this panel. I'd like to move on, if I may, to the other two factors of the Middlesex standards. There must be an adequate opportunity for Dr. Stimson to raise his constitutional claim. This court has held on several occasions that agencies may not invalidate federal statutes, and yet the constitutionality...
Federal or state agencies, did we say it?
Well, Your Honor, there are examples of both instances in the cases which...
What case has this court written that state agencies cannot decide the constitutionality of a statute?
Well, Your Honor, I would draw your attention to the Public Utilities Commission case, which I believe was a case involving a state agency evaluating the constitutionality of a federal statute.
No.
I beg
I'm
your pardon if
talking
I'm
about
mistaken.
a state agency looking at a state action
I beg your pardon.
determine that.
There is
The reason why I'm making the distinction is because of the wisdom of the court in the Pennhurst case.
Well, Your Honor, there is a case. Excuse me. There is a case which the petitioner has cited in their brief, and that is the Southern Pacific case in California. And that was, I would submit to you, Your Honor, an aberrational case of the California jurisdiction, which
Those are different from the aberrational cases in the Third Circuit.
Your Honor, that case dealt with a state statute and a state agency. And I would like to point out that the concurring opinion in that case by Justice Moss pointed out that the Supreme Court law is directly contrary, and he cited 3 cases where the Supreme Court has stated that agencies may not declare statutes unconstitutional.
Well, I mean, that might be in California, but a lot of agencies do all kinds of things all the time. I don't know a law that prevents them from declaring it unconstitutional, but even if that were so, I mean, there's this de novo. I mean, I feel a lot better about Judge Higginbotham's argument since I realized he wasn't talking about me, that they're dragging him from off the street. And what about, in other words, look, there's a whole line of cases which does apply this abstention doctrine to state proceedings. And here you have a de novo proceeding. And what's the difference between, I mean, is there any functional difference between what we have here and what the majority of the court and all those other cases, abstaining in criminal cases, in nuisance cases, in custody cases, in all kinds of things? What's the difference between those and this?
Well, Your Honor, I'd like to point out that on 2 occasions, the Supreme Court has stated that the availability of de novo review does not cure the defectiveness or the unfairness of the lower proceeding.
Well, that was Gibson, but I mean, that couldn't because it was a biased panel. This has nothing to do with a biased panel.
Well, Your Honor, this panel is just as defective as the Gibson administrative hearing was by reason of bias because of the fact that they are not empowered to decide the constitutional issue of this case. But there's an additional point on the de novo question which I'd like to raise. In addition to the fact that Ward v. Monroeville and Gibson v. Berryhill have said that doesn't cure lower proceedings defectiveness. And that is that only 2 years ago, in analogous circumstances, this court considered whether or not an exhaustion requirement should be imposed on Section 1983 plaintiffs who were trying to get out of administrative proceedings. And in an opinion by Justice Marshall in Patsy versus the Board of Regents, this court held that it would be unfair and wrong as a matter of judicial policy to impose such an exhaustion requirement. Now, precisely that type of situation is presented here. Dr. Stimson has a right to de novo review, but he doesn't have to exercise that right. At the conclusion of his administrative hearings...
Well, if he does exercise it, how long is he going to have to wait?
Excuse me, Your Honor?
If he does exercise the option of de novo review.
It could take a long time, Your Honor, which I think is an important point. He has a right now to have his constitutional claim vindicated in federal court. And I think to impose an exhaustion requirement on him would be unfair.
As a matter of fact, in this case, there was an initial suspension of his license, wasn't there?
That's correct.
And didn't the Court of Appeals continue the suspension of his license in this case?
After the temporary suspension, Dr. Stimson filed suit in federal court. The district court dismissed, and then the appellate court reversed. But throughout this entire 16-month period, Dr. Stimson has been without his license.
Yeah.
I'd like to raise one final point on the abstention issue before moving on to the federalism point.
Well, before you do, why should the doctor be in any better position than the person who had the theater and was showing obscene film? And in the opinion, the court said, in Ohio, even that you just have to exhaust it completely through the Ohio courts before you can come into the federal court. What you're asking for is something more advantageous for a surgeon than what the Supreme Court held in 1975 someone who runs a movie theater is entitled to.
Your Honor, there's a very important distinction, and that is that in the Huffman case, which I believe you're referring to,
Yes.
that case was already in state court. This is a case which is in the administrative context. Moreover, there's a second distinction, and that is...
But you could get in state court mighty fast on this.
That's correct, Your Honor, but it's not a question of options, it's a question of rights. Dr. Stimson has a right to be in federal court because of the unconstitutionality of this federal statute. But there's a second distinction of that Huffman opinion which I would like to raise, and that is that there was an issue of substantive state law here. And this really brings up the final point on the abstention question, and that is the state must have an important interest in the proceedings. And in the Huffman case, there was substantive state law being decided in that state court decision. Here, however, there is no state interest. There's no state policy at stake. There's only a federal policy. And indeed, the primary issue before the Division of Medical Quality was the constitutionality of subsection K.
Are you stating that a state has no right to be interested in whether its citizens prematurely die?
Your Honor, they clearly do have an interest, but what we're talking about is the particular claims which Dr. Stimson has raised in this hearing. Now, his primary challenge in this entire case is the unconstitutionality of the statute. He doesn't dispute the facts. At page 5 of the records, it's indicated that none of the facts are disputed. His whole claim is that the law that is being applied to me is unconstitutional. And since the state has no interest, there's no substantive state policy under state law being considered in that hearing, he has a right to challenge that federal statute in federal court. I'd like to move on, if I may, to the federalism issues which we have expressed. As an initial matter, there should be no question under the precedents of this court that Dr. Stimson, in fact, has the right to raise these issues. As a litigant, as an individual who has suffered injury through the operation of this statute, he has the right to raise his own interest, not the state of Ames' interest, but his own interest in the proper structural balance between federal and state power. Indeed, as this court has decided in recent cases, a litigant who has standing may raise the broader structural principles that are at work in the statute that he or she is challenging. I would draw the court's attention in particular to the Pacific Gas and Electric case of 1983, where this court allowed a litigant to raise the Commerce Clause and 10th Amendment challenges to the statute, which in fact were implicated by that case. And by analogy, since Dr. Stimson has been injured from the violation of federalism by the structural imbalance here, he has the right to raise that issue. With respect to the merits of our federalism claims, there are two issues. The first is that, as a condition on a federal grant, subsection K violates the clear statement rule of Pennhurst v. Haldeman. And that rule states that where Congress legislates in such a manner as to affect the federal-state balance, it must do so unambiguously. It must do so explicitly, so that the political processes of accountability may take full effect.
Well, what do you say of your opponent's argument that all of that's wrapped up and the clear statement requirement is satisfied by the words medically indicated?
Your Honor, we feel that this statute is ambiguous in a number of ways. But the most important way is the petitioner's interpretation of the statute. She requires this statute to require delicensing. Yet the plain language of the words of the statute say only that the state must have procedures in place. It does not specify...
Why can't one of the procedures be delicensing?
Oh, it can, Your Honor. Indeed, it can. But what we're saying is that it is not the only one.
Well, I mean, they can't legislate everything, can they? I mean, they say, we want you, state, to have some procedures that will make certain that nobody fails to give the operation to a child. That's all. You do it any way you want, and certainly delicensing is likely to bring it about.
Your Honor, that's precisely our point. Do it whatever way you want, are the words that you just said. We feel, and we indicate this at page 12 of our brief, that a number of other alternatives would satisfy the statute. The imposition of a...
You build a hospital. We insist that a hospital have an operating room. Can't say that. Take our money. We're the federal government. Build a hospital. has to have an operating room. Doesn't tell you whether it's wood, metal, how tall, surely they can say something like that, can't they?
Your Honor, the point is not, the point is simply that Congress, when it legislates to affect the federal-state balance, and I will explain this more thoroughly when we discuss the commandeering issue, but when they legislate to affect the federal-state balance, the states must know what is being required of them. And under this statute, the words say you have to have procedures in place. Now, that could mean a number of different things. It does not necessarily, as the petitioner suggests, require delicensing. That is a drastic...
But delicensing is a procedure.
It is indeed, Your Honor, and it is one option that the petitioner could have. But what we are disputing is the fact that it's the only option. We are saying that there are other alternatives that could be provided under the statute. The second issue is that if we assume, arguendo, that the petitioner's interpretation of the statute is correct, then this statute, subsection K, runs afoul of the 10th Amendment. If the petitioner is correct, then what has happened here is the federal government has decided on a specific federal policy, then used its spending power to effectively commandeer a state agency to carry out that policy for it. And that is in violation of the 10th Amendment.
How much money did Ames get out of this statute?
It's not clear, Your Honor, but the entire program is $6.7 million.
All right, so being one of the 50 states, they may very, very well be getting $100,000 or less.
Your Honor, the issue is not the degree of money.
I would suppose the statute provided for 10 cents. Would you think that the great state of Ames would be so coerced from that generous offer?
Your Honor, the issue is not the degree of money involved. There's a principle at stake here, and that is the integrity of the state's administrative apparatus. We're not challenging the federal government's ability to regulate a number of matters in various different ways. What we are challenging is their ability to take over the state apparatus of the state of Ames. Because as the record indicates, at 4 different occasions, page 2, page 6, page 11, and page 12, the state of Ames had never pursued this policy before the passage of subsection K. The petitioner felt required to do this. So essentially, we are presented with a situation where the state has abandoned its policy and adopted the federal policy because it felt it had to in order to avoid a cutoff of federal funds. And that, Your Honor, is our point, that this is...
Well, tell me, Mr. Thomas, suppose Congress were to enact a statute saying that hereafter grants for the building of roads in any state shall be withheld unless the state enacts a mandatory law requiring the use of seat belts. Would you say that went too far?
Your Honor, the only fair answer to that question is it depends on how Congress...
I don't ask for a fair answer.
Well, I'm going to give you one, Your Honor. The answer is that it depends on how the federal government went about doing that. If it did...
Well, it went about doing it just the way it said. We now have a program, and every one of the 50 states gets very, very substantial grants to build roads, and the Congress says hereafter no state gets any grant unless it enacts a mandatory law requiring the use of seatbelts.
That statute would probably be constitutional, Your Honor, because the federal government...
If it would, why wouldn't this one?
Because there's a difference in the level of intrusiveness. And that's why my first point about it, depending on how the federal government did it. If they did so in such a way as to actually take over the apparatus of a state administrative body and to change its policy against its will, then there would be a 10th Amendment problem. But I suspect, in the hypothetical which you've given me, the federal government could do so without directly interfering with the integral state functions of the state. In this case, however, we have a state that has abandoned its own policy because it's presented with the impossible choice of either abandoning its commitment to child protection or sacrificing a part of its sovereignty. And Congress must be held to a higher standard than that. It cannot place the states in a position of having to make that kind of a choice. If the court would allow, I'd like to make a few comments in closing. I'd simply like to reiterate that while the government may regulate in a number of ways, it may not pass legislation that begins to erode the fabric of our constitutional structure. If the meaning of statehood is to have any content at all, it must include the right to control a certain nucleus of integral state functions. We ask only that this court recognize that right before we begin to lose the structural integrity of our federalist system. Thank you.
Feldblum.
May it please the court. My name is Chai Feldblum, and I'm co-counsel for the respondent, Dr. Henry Stimson. I will be arguing tonight that Dr. Stimson has standing to raise the claims of infants and parents, and that indeed the statute before this court, the recently added subsection K of the Child Abuse Prevention and Treatment Act, violates the rights of infants, parents, and doctors. Dr. Stimson may validly raise the constitutional rights of infants and parents because enforcement of subsection K against Dr. Stimson would necessarily mean that third parties could not enjoy their constitutional rights. This court, in a number of cases, has held that a professional person injured by a statute may raise the claims of third parties if enforcement of the challenged statute against the professional would in turn dilute the rights of third parties. In this case, enforcement of subsection K against Dr. Stimson would necessarily mean that none of his patients, no infant, no parent, could ever choose anything other than medically indicated treatment.
No, they've said that isn't so. They're making a rather fine point. I grant, but they say, look, all that this license is being taken away for is that the doctor advised the parents to choose this course of action, as opposed, I take it, to dispassionately explaining the pros and cons of each of the courses of action. They're saying that that's the state, that's what the federal government means the doctor shouldn't do. And that's all he did, that's why his license is being taken away.
That is an assertion that the petitioner has made. However, it seems very clear from the proceedings that the license has been revoked not because Dr. Stimson reviewed with the parents the possible procedures, but because Dr. Stimson did not deliver the medically indicated treatment. That is what the superintendent said when she took away his license.
Well, given this uncertainty, and you say they did the one thing and they say they did the other thing, isn't that a pretty good reason that we should abstain?
Well, no, I think that in this case, as my
Let them tell us what they are doing. And I don't understand the medical facts of this anyway, and won't all that come to light a little bit if they go into the record and explain what the alternatives were and really give us the reason why they're taking the license away? Why shouldn't we abstain?
Definitely, we need to reach the medical issues at issue in this case. But on page 5 of the record, it does say very clearly that the facts are not in dispute. And the facts as they now stand are that the license was revoked because Dr. Stimson did not deliver the medically indicated treatment. The concept that it was revoked because of Dr. Stimson's discussion is something that does not appear in the record at all and appears for the first time in the petitioner's brief. Therefore, I think that this court could go in the assumption that the license has been revoked because the doctor has not delivered the treatment. It is certainly the common sense approach that the statute was addressing. The statute wishes to ensure...
Well, in page 2, it says that the defendant, Mitchell, says, in this case, the unprofessional conduct consists of prescribing a course of treatment under which no medical... uses the word prescribing.
Right. Well, the word prescribing would include both discussing the options and, in fact, going through. Assuming that...
So shouldn't we let them decide it, abstain?
Well, if the court would feel that that was really an essential point of controversy, was the license revoked because of the discussion as opposed to not giving the treatment, that would certainly be an issue, Your Honor. However, as we noted, the facts of the case seem to be that the concern is with doctors who are not ultimately, after discussing it, giving the treatment. Then because we argue that infants have a right to refuse certain treatment and parents have a right to make those decisions for their infants, Dr. Stimson may validly raise those claims.
What case has this court ever held that an infant or an adult has the right to refuse medical treatment?
This court, Your Honor, has not yet had the opportunity to extend the right of privacy to medical decisions. A number of state courts have done so, and we are hoping that this court will take the opportunity of this case to affirm that the right of privacy, which currently protects such decisions as whether to use contraceptives or have an abortion, also covers the right to refuse medical treatment. Moving to the merits of the case, which is what you are addressing, we argue that the challenge statute, subsection K, violates the constitutional rights of infants. It is critical to understand what it is that subsection K requires.
But when you talk about the constitutional right of infants, what you're talking about is the right of an infant to die at the age of 4 months old rather than 10 years old. And that is the constitutional right for which you're asking, a premature death.
We are asking for...
Isn't that what you're asking for?
Certainly, yes, because at times dying at 4 months may be more in the interest of that infant than dying at 4 years.
And what evidence do we have in this record that it was advantageous to that infant to die within 4 months over living a longer period where if the surgery had been done, there would have been less mental retardation?
If the surgery had been done, the infant would have lived perhaps a year, perhaps 4. What we know from the record is that spina bifida infants who have the range of disabilities and handicaps that this infant had often face a life that may be characterized by severe pain, suffering, constant operation.
It's law school.
Well, I would not be averse if this court found that there was a constitutional right of privacy to...
Well, Ms. Feldman, on this question, the district judge made this finding of fact, as I read it, at page 6 of the appendix, of the joint appendix. In the days following the delivery of the infant, Dr. Stimson and the infant's parents discussed the range of treatment options available to the child and concluded that a course of conservative treatment was the one that best met his needs. Now, does that have any bearing on the question that Justice Higginbotham just asked you?
This reflects your question from before as to whether this was perhaps medically indicated treatment. Both sides, before this case began, stipulated that the statute would apply to Dr. Stimson. In other words, that the treatment given was not medically indicated. That was something that both sides had agreed on, and in fact it is consistent with the way the federal government has interpreted medically indicated. To the federal government, medically indicated means that you focus solely on the infant's medical condition. In other words, if a proposed medical operation would benefit the specific medical condition to which it is addressed, if a shunt operation in a spina bifida infant will drain the water from that infant's brain, that operation is considered medically indicated. The fact that that operation may also result in a prolonged and yet perhaps painful life is, as set out by this statute, totally irrelevant and immaterial to the decision-making process. Now, the petitioner and we do not appear to disagree on this characterization of medically indicated treatment.
Well, apart from that, though, what is the significance of the finding that what the doctor did, agreed to by the parents, was the best that could be done medically for the child?
In our mind, it is the decision that this was in the best interest of the child would in fact mean that the child had a constitutional right to refuse that treatment. The way the federal government will be interpreting what Dr. Stimson and other doctors like Dr. Stimson have done in this case is not to accept this argument anymore, that this treatment is another medical treatment just like any other. That is an approach that doctors and courts have used, but as is made very clear by the regulations that this government has set out on medically indicated, that is not an approach they wish to take. For example, in the regulations it does say when medical care is clearly beneficial, that care should be undertaken. And then in the sentence immediately following, they describe what is not to be considered. Considerations such as anticipated or actual limited potential of an individual are irrelevant and must not determine the decisions concerning medical care. In other words, if an operation will not be medically beneficial, there's some muscle or tissue in the infant's brain so the shunt operation won't work, you no longer have to do that operation. It is not medically indicated. But if parents wish to not have the operation because they feel it's in the best interest of their infant to die at 2 days and not at 4 years, this statute no longer allows them to make this decision, and moreover, this statute does not allow anyone to make that decision for the infant. We therefore argue that the statute is unconstitutional on its face because it denies to the infant any individualized decision-making that would take into account more than just medical conditions.
Let's see, I gather what you're arguing is that even though it was a finding of fact that both doctor and parents concluded that what was done was the best interest of the child, that the statute forbade them from reaching that conclusion because the statute required that they go through with surgery. Is that what you're arguing?
That is precisely the point, Your Honor. And it makes sense in that the federal government is concerned that individuals are looking at more than just the medical conditions. Clearly, when they say it's in the best interest is encompassing the fact that it might be better for this infant to die at an earlier age than a later, not because medically the shunt operation and the spine operation will not work.
Are you really suggesting that the state or federal government do not have the ability to set a standard of health care on which there would be some disagreement by some medical authorities, but it is their collective judgment that in the overwhelming balance of cases, one course of conduct is better than the other?
We do not dispute that the state can set a standard of medical care. They can discuss whether a shunt operation should be done or not done because of medical conditions. What they have done here, however, is say you may only focus on medical criteria. You may not focus on the ramifications of a perhaps medically successful operation.
Well, how do you distinguish this in terms of the line of cases such as Jacobson, which deal with vaccinations, where there may be a case where one doctor says, for this person, I don't think, weighing all of the facts, it would be advantageous, but the Supreme Court has held that you can force vaccination even when a First Amendment claim is raised.
In Jacobson, the state could present a compelling state interest, that is the public health, and thereby override the person's constitutional right of religion.
And public health isn't involved in this case?
The compelling state interest, Your Honor, is what is different. Here, the infant starts with the constitutional right to say no to certain treatment through a surrogate decision maker. What subsection K does is destroy that right by effectively mandating life. Now, as with any other constitutional right, the state could pass such a statute if it was narrowly tailored to a compelling state interest. Certainly, the government raises its compelling interest of preserving life. But the very premise on which that state purpose is based is that life is in the best interest of its citizens.
No, what are these other things that would, if they're not medical things, and I assume pain and suffering and that kind of thing is medical, but what are these other things that will warrant the parents taking the life of the child? I mean, can't the federal government say, or the people speaking through it, we want to have a society where people do not take the lives of other people. Period. And therefore, we are not going to allow even the parents to use non-medical considerations to take the life of even their child.
The reason why, Your Honor, we have an interest in saying people should not be allowed to take away the lives of other people, that's a compelling state interest, is because ordinarily life is in the best interests of the citizens and the state must protect that. But what the
Constitution talks about life. not best interest.
True, but what the advent of modern technology has done is introduce complexity into the concept that life is always a good, so that in these cases of withholding treatment, it is precisely that premise, that prolonged life is in the best interest of this citizen, that is being called into question and being challenged. The state, therefore, cannot rest on its ordinarily compelling interest in preserving life to justify subsection K, and the statute unconstitutionally infringes an infant's right to say no through a surrogate decision maker.
Ms. Feldman, may I ask you, suppose we don't agree with you and think that the medically indicated is constitutionally appropriate as a standard for the Congress to adopt. Are you going to say anything whether there's any justification in that fact, in the state picking this provision out of the federal statute and using it in its licensing procedure to take away the doctor's license?
If the state interprets medically indicated the way that we do, in other words, what Dr.
No, the way
Stimson
that
did.
we do.
What?
If the answer is that medically indicated is constitutionally within the Congress power to adopt as a standard, is the state of Ames entitled to pick that up and rely on it to revoke the doctor's license?
Well, we still argue that the statute is not clear that revoking of a license is what is required by the statute. Certainly, the statute says
Well, let's get
medical
over that one
licensing.
too. Let's suppose we don't agree with you about that.
Well, if requiring medically indicated treatment would be constitutional, in
Yes.
other words, if this court would decide you can abrogate the infant's right to say no and the parent's right to
Yes.
choose for their infants, then the state of Ames is applying a constitutional statute. We believe there are other procedures they could use besides revoking Dr. Stimson's license, but they could. It would no longer be an unconstitutional statute. Not only is subsection K unconstitutional because it deprives infants of individual rights to have choices made on their behalf, but it deprives parents of their constitutional right to be the ones to make that choice. Now, we are not arguing that parents have a constitutional right to harm their infants.
You know, I sort of find this fiction overwhelmingly unfair when you talk about depriving a 4-month-old baby from making a decision about life. Even if it's a 4-month-old who may someday go to Harvard. At 4 months, it just seems to me that it's a fiction for us to talk about that. So why don't we just say we're talking solely about a guardian or surrogate, but we really aren't talking about an infant making the decision, are we?
We are certainly talking simply about the parent making the decision, but the parent derives its right to make this decision for the infant because the infant must start with the right to refuse treatment that would not be in its best interest. The decision to deliver treatment is as much of a choice as the decision not to deliver treatment. So certainly we are talking about the parent's right to make a decision for the infant that would be in that infant's best interest. Subsection K not only denies any individualized decision-making for the infant on the part of anybody, parent, ethics committee, courts, it also, we argue, is unconstitutional because it deprives the person who should be the decision-maker, the parent, from making that decision. We agree with the government that some response is appropriate to the new and sometimes tragic situation that modern technology creates. But the government's current response is a statute that cuts too deeply into infants' rights to have individual choices made on their behalf and the rights of parents to make those choices. We therefore ask this court to strike down subsection K as unconstitutional and thus save both infants and parents from its unbending harshness.
Mr. Tankersley?
I just want to make 2 points, and I want to start where Mr. Thomas started. and that was with his assertion that the crucial question here is who will be allowed to determine whether this child will be given treatment. I think Ms. Feldblum's argument has already indicated the crucial question here is not who, but how are we to decide whether treatment will be given to sustain this child's life. And the crucial issue before the court is how is anyone to decide this? This statute represents, in effect, a confession of ignorance on behalf of the government, which Ms. Feldblum and the respondent have been unwilling to make on behalf of parents. And that is that there is no way for any of us to know, this child's parents, Dr. Stimson, or anyone else, to know whether this child would wish to die rather than to have life in this particular situation. The considerations that Mrs. Feldblum is arguing that the parents should be able to take into consideration in determining whether to withhold this treatment are obviously ones that none of us can make for a person who is just beginning out at the very inception of life.
Well, you're viewing the unit as the individual. It's a statute. We're not talking about killing an innocent person. We're talking about not saving an innocent person, which to some people makes a significant moral difference. If no one knows whether or not this innocent person should be saved because of the difficulties in pain, suffering, quality of life, effect on the family, what happens to the other children, what's the right thing for the child, for the parent, isn't this the very kind of intensely personal, difficult, family-affecting decision that under our system of government, the Constitution wants to devote to the unit of the family rather than the unit called the state?
Well, Your Honor, first is the point that the family considerations are precisely those that would be impermissible in this situation. For the parents to take into account the financial burden of this child in determining whether it should be given life at all would clearly be contrary to the interests of the state. But more importantly, I don't think there is any moral difference between withholding treatment and having this particular child die in this situation. The procedures involved here, which were denied to this particular infant, are the normal procedures which are given. And if the respondent's assertion is that we could take into account the fact that this life may be painful, that this child may be retarded, or that it may impose financial burdens on the family, those considerations would not make any difference whether we're withholding treatment or deciding to have this child not live just by virtue of those considerations. And it is that effect, that fact, that those considerations must be excluded which justify the adoption of this standard, which requires that we only consider those objective considerations of the child's medical condition. The only other point I wanted to make was with respect to the paralysis that Mr. Thomas's argument would put the federal government into with respect to funding conditions. In his first argument on clear statement, he states that this is not a clear statement because the federal government didn't specify explicitly that they wanted delicensing procedures adopted by the state. And his second argument with respect to the 10th Amendment is when the federal government specifies particular procedures for the state to adopt, they violate the 10th Amendment. What this provision says is that states which adopt this federal funding program have to consider this form of withholding treatment as a form of child abuse and adopt procedures to effectuate that decision. It does not prevent the state from adopting alternative or additional procedures. And if you look on page 2 of the record, it clearly indicates that what Louise Mitchell did in this case was say that pursuant to this statute, we have to consider this child abuse. And I'm going to institute these proceedings against Dr. Stimson because of his unprofessional conduct. And that clearly is what this statute authorizes and provides, and is not in any way a violation of the clear statement doctrine of Pennhurst or the 10th Amendment, the ability of the federal government to affect the policy of states by virtue of the 10th Amendment. Thank you.
But we'll recess. Well, as you can tell listening to it, this wasn't it, an extraordinarily difficult exercise to put on these R lists. And I must say, all three of us feel not only unanimously, but very strongly that both sides handled it both in brief and in oral argument just superbly, absolutely superbly. But this again is it's one chore that judges have that the rest of you don't. We've got to decide who was the best brief and who was the best R list and who were the best combination. And our conclusion is that we'd say the best brief was the respondents. The best R list was Mr. Tankersley. The best combination was the respondent. It could just as easily have gone the other way in all three categories.
It's a very unruly court.
My gosh, everybody would be disbarred if we were in Washington. Justice Higginbotham would like to say something to you.
Well, I join in Justice Brennan in complimenting counsel for an extraordinary level of excellence. I congratulate Professor Tribe and colleagues for pulling together a problem more difficult than those I normally encounter. When I had the good fortune to argue in the finals at a little school in New Haven, Justice Jackson said, when lawyers prepare a case carefully, familiar with the facts and the law, they never lose. Their clients may, but they don't. And in a real sense, I believe that all of the counsel here did not lose. You were superb, and you're a great tribute to an extraordinary law school.
Please.
What was that school in New Haven? Professor Freund told me what it was. It's an acronym. It's Youth Against Learning and Education. I simply agree, and it was Larry Tribe and Will Hunter and the board who made up. What a case, my God. The only thing I'm not supposed to count on say anything about the merits, but I cannot resist saying something about one issue. I heard people talk about clear statement, and all I can say is if there were anything clear about this case, Tribe wouldn't have put it in. It was absolutely an outstanding argument. I wish we had the quality of argument that I've heard all the time in our court, and I'm very glad we don't have such difficult decisions to make. So I congratulate you all.
So thank you all.